may have some further enlightening.
Deputy Attorney General Greg, just briefly, so NRS 651.050 provides the definitional section for that law. Subsection K specifically says place of public accommodation means any nursery, private school, or university or other place of education. So that is sort of the subsection that we're talking about. And there's further Nevada case law, and that case is Clark County School District versus Buchanan, 112 Nevada 1146. It's a 1996 case, which has applied the place of public accommodation to a public school.
Thank you, Deputy Attorney General. Now, obviously, reasonable minds may disagree here, but I think there's precedent to support the continued inclusion of this particular and particular provision of the regulation. The other concern that was raised was with regard to compelled speech. Deputy Attorney General Ott, if you could perhaps help us navigate that and some of the changes that we've made in the particular regulation to address those concerns.
Deputy Attorney General Greg, so I won't restate the clarifications that you made about the changes to the regulation, changing language from requiring the use of certain pronouns or names to prohibiting the use of other pronouns or names. You stated that accurately. I will briefly go into compelled speech, and I'll limit myself to citations because I know Supreme Court citations don't make everyone as excited as they make me. The concept of compelled speech was first touched on in West Virginia State Board of Education v. Barnett back in 1943. Citation for that is 319 U.S. 624. That case involved daily mandatory participation in the flag salute and the Pledge of Allegiance by teachers and students. Non-participating students were subject to expulsion, and parents were liable for their child's activity with punishment of a fine or jail time. Students could not opt out or alter the message. The Supreme Court conceded that public schools could use the curriculum to nurture patriotism, but held that the requirement that students declare national loyalty went too far. The Supreme Court later held in Sorrell versus IMS Health, Inc., and that's 131 U.S.C. 2653, a 2011 case, that compelled speech is presumptively invalid. Presumably those are part of the reasons why the department made the change from use of certain pronouns to prohibiting the use of other pronouns. However, just as the Supreme Court has ruled compelled speech presumptively invalid, it is similarly held that schools cannot act with deliberate indifference to harassment that is severe enough to prevent victims from enjoying educational opportunities. That's Davis versus Monroe County Board of Education, 526 U.S. 629, 1999 case. So the current version of this regulation strikes a balance by allowing the discipline of the name or the pronoun when such use meets the existing definition of bullying, which is prescribed in existing law, which is 388, 122 through 124.
Thank you, Deputy Attorney General Ott. Ms. Reed, that exhausts my questions. Would you just cover for me one more time so I make sure that my notes are accurate? The provision that